Hello, and thank you for listening to this podcast. My name is Karen Killalea. I am a partner and head of the employment team at Maples & Calder, Ireland, the Maples Group's law firm in Dublin. So, unbelievably, another year has passed, and we want to share with our listeners to the Maples Irish Employment Law podcast some of the key highlights in Irish employment law from 2025 in terms of case law. We're also going to take a brief look forward at some important Irish employment law developments that are coming down the tracks in 2026. So, as always, before we get started, some housekeeping. If you are listening in from your usual podcast app, you will find the resource documents that we reference throughout the podcast and speaker information in the description. If you've clicked on the media player link, which we sent to you by email, then you'll find this information in the notes section. Usual caveat, this podcast contains a general overview of various Irish employment law updates over the course of 2025. It does not constitute legal advice, and if you have a specific situation or question, please do reach out to the team for tailored legal advice. Just to note, for any listeners who are practicing solicitors in Ireland, this podcast is eligible for CPD points. And last but not least, please do subscribe on Apple Podcasts, Spotify or Google Podcasts, and you'll be notified of when our new episodes drop. So I am joined today by my colleagues Ciara Longaigh and Christina Connaughton, who are both associates on the employment team here at Maples in Dublin. I am very, very grateful to both Ciara and Christina for their assistance in putting together this 2025 wrap and 2026 look forward. So thank you very much for your assistance. And just in terms of what we're going to be looking at specifically, so we've picked out a few cases that we hope will be interesting to listeners, particularly those who have responsibility for people matters in Ireland. So we're looking at some Workplace Relations Commission decisions on gender discrimination, on age discrimination. We touch on the use of AI tools by complainants in bringing claims before the Workplace Relations Commission in Ireland. We are going to switch over and talk a little bit about redundancy consultation. We had a helpful decision from the High Court in Ireland this year on redundancy consultation, so we'll take you through that. There was a very recent, as in the past few weeks, decision from the WRC about reasonable accommodation and the management of disability in the workplace, so we'll take a look at that. Christina is going to talk through a recent case on worker classification. Ciara is going to take us through auto-enrollment, which, as everybody knows, is coming up on the 1st of January, and that is an evolving situation with regulations expected imminently. I will also talk about pay transparency, which is a subject close to everybody's hearts, particularly if you're working in HR or employment law, because that is coming down the tracks fairly quickly as well next year. Okay, so to start off, I think, Ciara, we will turn to you and let's talk about auto-enrollment. So first of all, who is in scope, and can you also summarise the opt-in and opt-out position?
Yes, absolutely. So employees will be automatically enrolled if they are aged between 23 and 60, if they earn more than €20,000 per year, and if they are not already contributing to a work or private pension through their payroll. Employees aged between 18 and 23 and 60 and 66 who do not fall within the scope of exempt employment for the purposes of the legislation can also choose to opt in voluntarily to the scheme. There's also an opt-out window, and employees can opt out between 6 and 8 months after the date that they've been automatically enrolled or re-enrolled, and employees who opt out will be automatically re-enrolled every 2 years.
Okay, great. And certainly our experience would be from clients, particularly based in the UK, that there's quite a bit of apprehension about the administrative burden that auto-enrolment will place on employers in Ireland. Is that a little bit misplaced, that apprehension? Tell us a little bit about how this is going to run.
Yes, I think the hope is this will run quite smoothly once it becomes operational from 1st of January. So to kind of back up a little bit and kind of give it a little bit more context, the auto-enrollment retirement savings system will be called My Future Fund, which has been dubbed MFF for short, and it'll be operated by the National Automatic Enrolment Retirement Savings Authority, or NERSA. So NERSA will manage all aspects of MFF and will work closely with employers and payroll providers. Ireland is the last OECD country to introduce auto-enrolment and will operate the fund independently via NERSA, with the portal going live from the 1st of December for employer registration. It is best practice for all employers to sign up to the portal, even where all employees are actually exempt from auto-enrolment. And this is to prevent a situation in the future where an employee may have been, forgotten or not added to the pension scheme, or added at a later date for whatever reason. We're informed that the portal will be user-friendly and it'll only take 5 to 10 minutes to set up an account. So it's best practice to get that up and running as soon as possible. Once auto-enrolment begins, NERSA will carry out employee eligibility assessments. If an employee's pay crosses the relevant threshold during a pay reference period, NERSA will issue what is called an auto-enrolment payroll notification, or APN, to the employer or the payroll provider. This operates much like Revenue's existing payroll notifications. It's essentially a formal prompt that confirms eligibility and tells the employer the contribution rate to deduct. It should be noted, NERSA will be utilising a 13-week look-back period over September, October and November 2025 payroll. NERSA will be flagging any employees earning over €5,000 during these 3 payroll months, as that would equate to €20,000 annually. It's important to understand that if an employee decides to join the company occupational pension scheme in December this year, that employee in question may be auto-enrolled despite having joined the occupational pension scheme because of that look-back period. However, there will be a mechanism available through the portal for refunds for any incorrectly enrolled employees or for double collected months. When an APN is issued, employers must make sure that the correct contributions are deducted from pay and sent to NERSA for the relevant period. At the moment, there hasn't been any specific guidance on administrative costs for employers beyond the projected employer contribution rates. Practically, contributions should function like any other payroll deduction, and the main focus will be on correctly applying the rates set out in the APN. There is a possibility that employers will have to run their current pension scheme in parallel with auto-enrolment. This is because employers can't currently require employees to join an occupational pension scheme before auto-enrolment begins, and therefore some employers may find themselves running their existing schemes alongside MFF once the system goes live. NERSA's design aims to minimise the extra administrative burden, but employers should still expect some coordination between the schemes. However, recently the Department of Social Protection has warned that some employers are attempting to avoid the new auto-enrolment scheme by compelling staff into less favourable employer-only schemes, contributing 1% of their salary, which is well below the phased contribution levels for auto-enrolment, which are starting at 1.5% for both employer and employee, rising every 3 years to 6% by year 10, which is also boosted by the state top-up of €1 for every €3 saved by the employee. The Minister for Social Protection is urging employees to read up on the scheme, compare the employer alternatives being offered, and note that the fund is portable and owned by the employee. The government plans to introduce secondary legislation to prevent token schemes undermining the system. Employers won't need to make auto-enrolment deductions until they receive an APN. Importantly, penalties for non-compliance can't be enforced until an APN has issued. Before that point, employers won't have the necessary information to apply the correct deductions.
That's great. Thanks, Kieran. Yes, it is interesting that there's been quite a lot of commentary, certainly in the media recently, around that point. I mean, our experience for sure would be that a lot of employers with existing occupational pension schemes are keen to bring their employees who are not members within the scope of that scheme and to join up to that scheme, and that is permitted at the moment. So look, we'll need to wait and see what emerges in terms of regulations, which will address what is perceived to be, as you say, sort of an undermining or an avoidance, but in fact is permitted, at least as matters stand. So look, that's great. Plenty to think about there. And I think, again, it's kind of getting a little bit late in the day. A lot of employers have already taken steps and are sort of clear on what they're doing. But for any employees perhaps, newly arrived and scaling in the country, what are your sort of top tips as to what they can do to prepare for auto enrollment?
Yeah, well, I think the kind of the first important practical step for employers is to review the workforce and identify anyone who's not currently in a pension scheme and decide the approach for those employees. For example, will they be invited to join the existing scheme ahead of auto enrollment, or will they be auto enrolled? However, as I mentioned, that look back period was from September to November this year. So if an employee decides to join the existing scheme over the next couple of weeks, they may require a refund, as they may already be captured by NIRSA when the go-live date kicks in after Christmas. As things stand, we don't know as yet the exact timing or process NIRSA will use to reach out to employers, but we do know eligibility assessments will be run and APNs issued once the system goes live. So the next practical step is for employers to register for the portal, as I mentioned, as soon as it goes live, as then an employer can assess if any of their employees have actually been caught by auto-enrollment. I suppose it's also important to recognise this isn't going to be a once-off for employers and will soon become a fact of life for all Irish employers. At a base level, employers should note that auto-enrollment and contribution collection will start from first payroll that is run after the 1st of January 2026, and no contribution will be sought or collected before that date. So employers should budget accordingly and be ready to begin contributions as soon as they receive notice from NIRSA.
Yeah, exactly. And probably the only thing I'd add to that is certainly we've been assisting clients to amend their template contracts for new employees going forward to reflect the fact of auto enrollment. And we're certainly encouraging employers to provide information on the relevant links and resources to auto enrollment so that ultimately employees can decide what they want to do in relation to their retirement funding, whether that be within an occupational pension scheme or within the MFF system, as you say. Okay, that's brilliant. Thank you for that. So we are, as we usually say in these situations, we're going to shift gears a little bit, and we are now going to look at a couple of interesting WRC decisions. So 2 discrimination cases that we're going to look at today. And Christina, I think you're going to talk us through the first case. So this is a female complainant versus the HSE. Very recent decision. This relates to a complaint of sexual harassment and gender discrimination. Really quite a high award for the employee who is successful in their claim. And I don't think I'm speaking out of turn where I say that there are some perhaps key learning points for employers in Ireland in terms of perhaps how not to handle a complaint of sexual harassment in the workplace. Do you want to just talk us through that?
Thanks, Karen. Yeah, so this is this decision of a female complainant versus the health service executive was from the 28th of October of this year, 2025. And the adjudication officer upheld a complaint of sexual harassment as gender discrimination, which was brought by a female pharmacist against the HSE. The adjudication officer awarded 1 year's remuneration as compensation. This amounted to €86,717 and ordered that the complainant's stress-related sick leave be disregarded for the purposes of calculating her sick leave entitlement. So this case involved a female hospital pharmacist, the complainant, who alleged multiple incidents of sexual harassment by a senior pharmacist between May 2023 and June 2024. The complainant reported the harassment in June 2024, and subsequently the senior pharmacist in question admitted to 2 incidents in a written apology, characterising his behaviour as office banter that was intimidating and offensive. A key element to this decision is that the respondent took no disciplinary action for over 12 months, notwithstanding the admission by the senior pharmacist of wrongdoing and the implementation of safeguarding measures which were repeatedly breached, causing the complainant to take stress-related sick leave on 2 occasions. The complainant was moved between locations multiple times, and meanwhile her harasser remained in his position. The complainant stated that she felt ostracised as she was not in a position to take part in office meetings, given the senior pharmacist remained in place. And for 70% of her working week, she wasn't able to use the dispensary facilities where he worked. The adjudication officer found the complainant to be a credible witness and noted that the senior pharmacist had actually admitted to 2 incidents and apologised. And the adjudication officer concluded that the facts established a presumption of discrimination that the HSE had failed to rebut. It should also be noted that at the hearing, no cross-examination took place, and the respondent's representative stated that they weren't questioning the complainant's credibility or version of events.
And just even to pause there for a moment, like it does seem a little bit extraordinary in this day and age that there was such a response. Does the decision cast any light on the employer's position? Like, what was their explanation for the delay, I suppose, and the lack of effective measures to reverse the situation where the harassment had really been admitted?
Yeah, Karen. So the adjudication officer questioned the respondent about why the senior pharmacist wasn't suspended with full pay pending the investigation of the complaints. And the respondent admitted that he was entitled to due process, natural justice and fairness during the investigation. But the adjudication officer questioned the complainant's entitlement to the same due process and natural justice and fairness and her right to a safe working environment.
Yeah, indeed, understandably. And so then what happened?
So the adjudication officer noted that 13 months after the complaint, that's kind of when the hearing took place, no disciplinary action had actually been taken against the alleged harasser, and the investigation was unreasonably delayed. The adjudication officer agreed with the complainant that the HSE policies didn't make reporting sexual harassment easy, and the complainant was unable to get a support contact person during the year-long ordeal. The adjudicator held that a reasonable employer would have placed the senior pharmacist on paid suspension during the investigation and criticised the HSE for prioritising the accused position over the complainant's rights. The WRC awarded the complainant compensation equal to 52 weeks remuneration for the effects of discrimination and directed the HSE to disregard her 2 stress-related sick leave periods when calculating her annual and multi-annual sick leave. This decision should remind employers of the importance of acting swiftly on employee complaints to ensure that they're investigated in line with dignity at work and grievance and disciplinary procedures and the associated WRC codes of practice.
Thanks, Christina. Yeah, that is a really interesting decision for employers in Ireland. And it's also just a timely reminder about the powers of the adjudication officer to make directions and in effect give instructions to an employer to change their practices or their policies. So thanks for that. Okay. So, Ciara, we're going to turn back to you for a moment, and you are going to talk us through another decision from the WRC, and this is the case of Seamus Casey versus Irish Heart Foundation. We touched on the Mallon case, the Supreme Court decision, in a previous podcast, which looked at the whole area of age discrimination. Can you tell us about this decision? The Mallon principles were upheld. Just talk us through what happened.
Yes, exactly. And this was quite an interesting decision and dealt with a topic that comes up more and more in practice for us, how to handle a request to work longer beyond a retirement age. So in this case, the WRC partially upheld complaints brought by Mr. Casey, the complainant, who was a 68-year-old stroke group coordinator who was employed by the Irish Heart Foundation from 2015 to the end of 2023. The adjudication officer in this case found age-based pay discrimination had occurred, however, rejected claims of discriminatory dismissal and the claims in respect of the conditions of employment which the complainant had brought. So the complainant initially worked on a full-time basis, receiving €16.48 an hour, and he hit the organisation's retirement age at 65 in March 2020. However, he continued to work on a series of one-year fixed-term contracts, 4 contracts altogether, and in late 2022, his hours were cut to 20 hours per week, and he was told that his final contract would end on the 31st of December 2023. Complainant wanted to keep working until age 70 to align with the state pension timing. However, the respondent refused to renew the contract. The complainant raised 3 complaints before the WRC. Firstly, he claimed that he had been dismissed in a discriminatory manner because of his age. Secondly, that his pay was discriminatory compared to younger colleagues. And finally, that his conditions of employment were discriminatory. The complainant argued that he was paid €32,500 per year. Meanwhile, younger co-workers doing similar work received salaries of between €38,000 and €39,500. The respondent argued that the higher paid roles required different qualifications and reflected a restructuring, but they didn't produce documentation that clearly showed how the roles differed. The respondent also made a goodwill back payment of €453 in December 2023, which the adjudication officer saw as effectively acknowledging the pay gap. The adjudication officer noted that the current legal position on retirement ages, as set out in Malin, as you've mentioned, Karen, where the Supreme Court held that a mandatory retirement age does not constitute unlawful age discrimination, where it pursues a legitimate aim and the means of achieving that aim are appropriate and proportionate. The complainant succeeded in respect of his equal pay claim. The adjudication officer determined that the complainant had been doing like work to his younger comparators and that the respondent hadn't shown an objective justification for paying him less, so age-based pay discrimination existed for the purposes of Section 7 of the Employment Equality Acts. The WRC awarded €1,363.12 in arrears, which was limited to a 3-year look-back period to the complainant, and compensation of €15,000 for the effects of discrimination. The adjudication officer said that the award was effective, proportionate and dissuasive in turn, in line with the EU legislation. It is also worth noting on the issue of age discrimination that a new piece of legislation is currently before the Seanad, the Employment Contractual Retirement Ages Bill 2025. The aim of the bill, once enacted, is to allow employees the option to notify their employer in writing that they do not consent to retiring at the contractual retirement age and that they wish to work to the pensionable age. The bill will apply where an employer has a contractual retirement age which is below the pensionable age. And I should mention that the pensionable age has the same meaning as the Social Welfare Consolidation Act of 2005, meaning 66 years of age. Where an employer receives this notification, they cannot enforce the contractual retirement age without providing a written response within 1 month of the employee's notification. An employer's written response must be objective and reasonably justified by a legitimate aim and show the means of achieving that aim are appropriate and necessary. An employer will also be prohibited from penalising an employee who raises a notification, and if an employer breaches their obligations to provide a response to the employee's notification or penalises an employee for raising a notification, they may face a WRC complaint brought by the employee and or several criminal offences and fines provided for under the bill. If enacted as currently drafted, the current case law, such as the Seamus Casey decision, which we've just discussed, as to what this is considered to be objectively and reasonably justified by a legitimate aim and what is appropriate and necessary will remain very important.
That's great. Thanks for that, Ciara. And I suppose in a nutshell, the position remains that contractual retirement ages remain very much under pressure and will certainly need to be approached with some care by employers. And it is very important to have regard also to the Code of Practice on longer working when considering requests by employees, which we are increasingly seeing in the market, to work beyond the contractual retirement age. Okay, so look, thanks for that. Now, turning to another topic, Domino's Pizza, Connaughton. Let's talk about worker misclassification. So listeners may recall that together with Will Fogarty and Andrew Quinn on the Maples tax team, we did a deep dive on the Supreme Court decision in Connaughton. You'll find it in the notes. We'll put a link into it. So we are going to take a look at a recent WRC decision which looks at the whole issue of worker misclassification. Listeners will also be likely aware that Irish Revenue has now issued comprehensive guidance. So we'll put a link to that into the show notes also. But Christina, can you walk us through this recent decision where the Connaughton tests were applied and tell us a little bit about the decision?
Absolutely, Karen. The decision you mentioned is the Paul Lingard versus Ranridge International Limited in examinership case. And this decision cited the landmark Supreme Court case of 2023 in the Revenue Commissioners versus Connaughton trading as Domino's Pizza. We're aware this case has been very high profile, and as Karen mentioned, we with our tax team did a deep dive on it. So we won't go into too much detail, but to just give a brief bit of background, in Connaughton, the Supreme Court set out a 5-step structured framework for determining the employment status of an individual. And the 5 factors identified by the Supreme Court are as follows. So first, does the contract provide for payment of wages or other remuneration in exchange for work? Second, if so, is the worker required to perform the services personally, or can the work be delegated to someone else? Third, if the answer is yes, then does the employer exercise sufficient control over the worker such that the arrangement is capable of amounting to a contract of employment? Fourth, if these Three prerequisites are satisfied. The next factor is assessing if the terms of the contract, read in light of the factual matrix and the parties' actual working arrangements, point to a contract of employment or to some other kind of contract. And fifth, finally, is there anything in the specific legislative regime at issue that must be taken into account? The Supreme Court effectively identified the fourth factor as the key question in determining the status of an employee. And the Supreme Court also emphasised that the parties' own description of their relationship in an agreement isn't determinative and that the court will decide the true legal status by applying the aforementioned five-step framework.
Absolutely. And I suppose that's key, what you mentioned there, that no matter what label the parties put on the relationship, it is really important to conduct the analysis by reference to what are really the very helpful, I think, clarifications provided by the Karshon test. So yeah, tell us what happened.
Exactly, Karen. So in February of this year, the WRC in the Paul Lingard versus Ranridge International case emphasised that they look behind the terms of a contract or agreement to interrogate how the parties actually operate day to day. So the facts of this case concern the employment status of Mr. Lingard, the complainant, and his entitlement to unpaid invoices, which he was claiming were wages under the Payment of Wages Act 1991 by the respondent, Ranridge International. The company was in examinership at the time. So the case essentially hinged on whether the complainant was an employee or an independent contractor. The complainant and the respondent commenced their working relationship in 2020 in July, and that ceased in April 2024. And the focus of the case was whether the relationship between the parties was a contract of service, meaning an employee-employer relationship, or a contract for service, where an independent contractor would be engaged by the company. The adjudication officer scrutinised the actual day-to-day working arrangements to determine the factual working relationship between the parties and applied the principles from Karshon that I set out a minute ago. So the adjudication officer utilised those Karshon factors and found that first, remuneration was provided for work performed, albeit under the arrangement between two commercial entities. Next, although the complainant's contractor agreement allowed for substitution of another individual under certain circumstances, that right was limited and was never actually exercised in reality. And finally, while there was no capacity for day-to-day micro supervision of the complainant's work, a close reading of the contractor agreement revealed that the degree of control over the complainant was expressly set out. There were illustrative provisions, including stipulated deadlines, a requirement to clock in and clock out, and the potential requirement for a medical certification in cases of absence. And the contract also contained restrictive covenants in the event of termination. So after careful consideration, the WRC ultimately found that the relationship on a day-to-day basis, the working relationship referenced by the Supreme Court, was on the balance of all probabilities that of employee to employer contract of service, irrespective of the agreement's written clauses. And the WRC accordingly determined that the complainant was entitled to €8,500 in the form of unpaid wages on termination. This case is significant as it emphasises the WRC's willingness to lift the corporate veil and look behind an agreement between a worker operating through a corporate entity and an employer to assess the true relationship between the parties. And it further aligns with the developing Irish employment law approach, which scrutinises the control, integration and economic dependency rather than relying on boilerplate labels of employee and contractor. A clause permitting substitution that's never used, non-compete clauses during the duration of the contractor agreement and for a period of 24 months thereafter, and the requirement for a certificate of medical fitness are not typical requirements in an independent contractor relationship and are much more akin to that of a typical employee-employer relationship. So the key takeaway for this case is that the true substance of the working relationship is decisive. It dispels the notion that engaging an individual through a limited company is a risk-free way to retain them, and it confirms that an individual and a company can't use a corporate structure, such as a limited company, to circumvent an employee relationship or an employment relationship. This decision comes in kind of amid heightened scrutiny of worker classification following reports that RTE has paid approximately €4 million to the Revenue Commissioners and the Department of Social Protection for misclassifying workers. And it underscores the significant financial and reputational risks involved in misclassifying workers.
Thanks, Christina. Yeah, that's a really important case for employers in Ireland to be aware of. And if I can just, I think that's an excellent summary. If I can just maybe summarise 4 or 5 then key takeaways. Firstly, I suppose, make sure that you align your contractual documentation with the reality of the situation. So if it is in truth an employment situation, it is better to document it as such. And at least from that perspective, everybody is clear, everybody understands what the liabilities are, not only in terms of Department of Social Protection deductions and withholdings and income tax withholdings, but also from an employment law perspective. I think, secondly, as you said, we need to stress test those contractor hallmarks, those features, and a substitution right must be real and not theoretical. I think a third takeaway is that sort of supervision where it's being exercised in a true sort of contractor relationship should not be that day-to-day direction and control that you would expect in an employment relationship. Fee structures should really reflect deliverables. They shouldn't look like or feel like salary type periodic payments. And as already mentioned, in September of this year, the Revenue Commissioners issued guidance offering a time-bound process for employers to correct misclassification of employees. So employers should consider whether they need to avail of that, and we have the links to it in the show notes also. Okay, so we are now going to look at something slightly different. We are going to talk about a very recent case, so a case that was published literally in the past few weeks, certainly at the date of recording, so in November of 2025. And this case concerns disability discrimination in the workplace. So it is the case of versus the DPP, and it concerned a complainant who suffered from alcoholism, anxiety and depression. And the claimant had had a period of absence from work where he undertook a residential treatment program for alcoholism in early 2019. He did have a subsequent period of medical absence about 3 years later. But after the initial period of residential treatment, in terms of what is reported in the decision, it appears that he returned to work in 2019. He advised his manager that he had been absent due to treatment for alcoholism. He didn't appear to ask for any particular accommodations at that time. In fact, he reported that he was doing well. And the decision also records the evidence of a occupational health report, which was prepared in relation to him on his return to work. And it appeared to record that he didn't have any issues and that he did not need any accommodations at that time. So what was really interesting about this case was the analysis of the extent to which an employer is required to actually proactively provide reasonable accommodation for an employee who has a disability. And in particular, in circumstances where the employee does not appear to have communicated any clear request for reasonable accommodation. So if we dive into the facts and the background here, and we are extracting this from the reported decision. So what appears from the decision is that the employee complained that he had been discriminated against on the ground of his various disabilities, in that he said his employer had failed to promote him, had failed to provide him with training, had failed to provide him with reasonable accommodation, and had failed generally to take his disability into account in the context of his conditions of employment. So some of the evidence that was given at the hearing included matters such as he complained that he had not received a standard salary increase that was applied to other employees when he returned from his absence due to illness in 2019. Interestingly, when he then complained about this, the evidence shows that the decision was quite quickly reversed by his employer. His employer had not appreciated, or at least those in payroll and charged with the making of these changes to payroll, had not appreciated that his absence was due to disability, and that decision was quickly reversed. He had also complained, by way of evidence of discrimination, that other colleagues had been promoted ahead of him. He complained that he had not been assigned complex cases. He complained that other more junior colleagues were being assigned more complex cases than he was being assigned. So interestingly, quite a lot of evidence was given at the hearing across a number of different witnesses, and one of the employer's witnesses was able to give quite detailed evidence of a breakdown of how work was assigned in the department in which the employee worked, and was also able to give evidence which made it appears quite clear, at least to the adjudication officer, that the employee had not been treated differently or less favourably to anybody else within his division in terms of the distribution of interesting and complex work. The employee also claimed that he had requested to be transferred to another division, and he claimed that this request for transfer was ignored. Now, again, the respondent employer gave quite detailed evidence about this request, and in particular, the respondent employer made the point that the request to transfer was never made in the context of any appeal or request for reasonable accommodation. Further, the employer was able to demonstrate that the complainant had not been treated differently or less favourably to other employees who had requested transfers or who had actually been transferred. A couple of other things that the complainant had raised as evidence of discrimination. He said that he had not been permitted to attend a training course. Again, the employer was able to give evidence countering this, and they pointed out that of the 19 people who applied to do the particular training course, only one was actually deployed to go on that training course, and the others were refused the opportunity to attend the training course on the basis that it was not relevant to their work. So it looks like this hearing probably took quite some time because of all of the witnesses who were called to address the various limbs of the employee's claim. So what did the adjudication officer decide, having heard all of that evidence? So the adjudication officer found that the claimant had failed in his claim in terms of evidencing less favourable treatment by reason of his disability. And the reasons for that decision were as follows. So in terms of the salary increase issue, the adjudication officer found on the evidence that there was a very plausible explanation for the delay in paying him a salary increase. The adjudication officer found that had the employee actually explained to the relevant individuals in the HR and payroll department, then he would not have experienced a delay in receiving the salary increase. So no inference of discrimination there. Likewise, in relation to the training course, the adjudication officer accepted that evidence and was satisfied that there was no inference of discrimination. Furthermore, in relation to the complaint that he was being treated less favourably in terms of not being deployed to the more interesting and complex cases that would allow the employee to be promoted and to learn and to progress in his career, the adjudication officer accepted the detailed evidence by the employer regarding the allocation of work, the number of complex cases that were in that particular department, and how that work was distributed amongst his colleagues. So again, on the basis of that quite detailed evidence, the adjudication officer appeared to accept that there was no link whatsoever between the distribution of work and the complainant's disability. So there was a sort of a second limb to the claim, which was essentially that the employer had failed to provide the employee with reasonable accommodation. And quite helpfully, as is always the case in these decisions, the adjudication officer just summarised the key principles in terms of the law and the obligations on employers when responding to and handling and helping an employee to manage a disability in the workplace. So what the adjudication officer said was reasonable accommodation or appropriate measures are measures which are effective and practical. They're measures that are needed in a particular case to, for example, adapt terms and conditions of employment, to adapt a place of business, to adapt patterns of working or the distributions of tasks, the provision of training, etc., in circumstances where those effective and practical measures will assist the employee to, if you like, perform their work on a level playing field with those who do not have a disability. Now, interestingly, on the facts of the case here, the adjudication officer found that the employee had not been clear about his request for reasonable accommodation. He had not complained at any time prior to the institution of the WRC claim. any of the requests that he had made. So, for example, in relation to the request to transfer to a different team, he had not contextualized that against the backdrop of his disability or any need for reasonable accommodation in order to assist him to work. So, interestingly, counsel for the claimant in this case had referred to an opinion of the Advocate General of the CJEU in a case known as Connaughton versus Ferroser Servicios Auxiliares. I'm probably really garbling that pronunciation, but we'll put it in the show notes so that you can look it up. And in that case, it was an opinion rather than a case. In the opinion of the Advocate General, they stated that the obligation to provide reasonable accommodation will be triggered when the employee has told his employer of his disability and its extent, together with all relevant surrounding circumstances. And in that particular case, so the case that was the subject of the Advocate General's opinion, it was found that the employer ought reasonably to have been aware of the employee's disability and ought to have considered accommodations that it could put in place to keep that employee at work. So that was a dismissal case, which is slightly different to the case we're talking about now, which is not a dismissal case. In any event, the adjudication officer in the case found that there were some similarities with that situation, in that 3 managers within the employer were actually aware of the complainant's alcoholism and anxiety and stress. The adjudication officer also found that the HR department had been informed that the employee had been treated for alcoholism. However, the complainant had not specifically asked for support to do his job. And in fact, he had said the opposite when he returned from a period of absence. He had said he was fit, he was feeling well, and he did not need any reasonable accommodation or appropriate measures to be put in place. So some of the following comments by the adjudication officer are nonetheless important, and there are always learning points from these decisions. So the first thing was the adjudication officer said, look, considering that the employee had been with the employer for 22 years, he knew his way around the organisation, and he should have been able to reach out to the disability liaison officer, and he should have been able to reach out to HR and just be a little bit clearer about asking for support and in relation to the various requests that he made, making sure that he had articulated that as a request for assistance, because the adjudication officer found that really the complainant seemed to have given the impression to his colleagues that he was looking to move on in his career, that he wasn't struggling, and that he was looking to take on more complex and, as he said, more interesting work. So that's the first thing. There was an obligation, a duty on the part of the complainant to express himself clearly in terms of what he needed. Equally, the adjudication officer was a little bit critical of the employer, and the adjudication officer said that on the return to work by the employee after his period of residential treatment for alcoholism, a meeting should have been arranged with someone from the HR department to find out why he had been absent, to find out if his work was a contributory factor and what could have been done to help. And certainly that seems to be sensible advice. And as the adjudication officer said, it's regrettable that this action was only taken when the employer heard that this complaint had been filed. So the adjudication officer described the employee's failure to communicate as a serious flaw in his claim, and on that basis, the claim failed. So in this particular situation, the notwithstanding the fact that the employer was aware of the employee's alcoholism, the employee had provided no information regarding the extent of his disability or the relevant surrounding circumstances. And as such, the conclusion was that the employer's duty to provide reasonable accommodation was not triggered. So an interesting decision. It's quite a long decision, but we will pop that into the show notes as well. So Ciara, turning back to you and shifting gears again, there was some commentary recently in the media about a WRC decision touching on the use of AI tools to create legal submissions in the context of WRC claims. So some interesting comments by an adjudication officer, and certainly this is something we are seeing quite a lot in practice. AI is obviously an important efficiency tool, and it has been appearing in submissions. So Ciara, can you tell us, what did the adjudication officer have to say about the use of AI?
Well, certainly AI has been at the forefront of discussions in the legal world in 2025, as you say, Karen, and the issue arose in the recent decision of Fernando Oliveira versus Ryanair, which showcased the perils of using AI, in particular in WRC submissions. In finding the complaints of discrimination, victimization, harassment, and sexual harassment were not well-founded, the WRC adjudication officer was particularly critical of the complainant's use of AI in his submissions, which included what appeared to be phantom citations, and called this an abusive process. So listeners should note the complainant's use of AI wasn't the actual reason for the complaints failing. In respect to the discrimination claims, the complainant failed to raise a prima facie case of discrimination. In respect to the victimization claim, the complainant failed to demonstrate a causal link between his concerns raised and the subsequent actions of the respondent. And in respect of the harassment and sexual harassment claims, the complainant failed to provide sufficient factual evidence to support his claims. However, it was interesting that the WRC did focus in on the use of AI in the submissions. And since then, the WRC have actually published specific guidance on the use of AI tools to prepare material for submission to the WRC. So the guidance note was published very recently on the 30th of October. The guidance highlights that the party submitting the materials must take full responsibility for the content. And it is also highlighted that if any legal information is incorrect or misleading, it may negatively affect the party's case, and that parties may be asked to explain their submissions or provide clarification. The guidance specifically refers to the Ryanair decision, which I've just mentioned, and outlines the risks associated with relying on AI tools. There's also provision for an optional disclosure to the WRC that AI has been utilised in the preparation of the submissions. However, the guidance does note that this disclosure statement is optional. However, the WRC do seem to encourage that the use of that statement, as it does promote transparency.
Okay, thanks very much for that, Ciara. Very helpful to have that guidance. Now, another upcoming change which we want to talk about is the EU Pay Transparency Directive. So this is being introduced into Irish law on the 7th of June 2026, so about 6 months or so from now. We do not have draft legislation yet, which will help us to interpret better the obligations on employers in Ireland arising out of this directive. So watch this space, and we will certainly update listeners as soon as we have sight of the draft legislation. In any event, for now, based off the directive, we are going to talk through some of the key changes for employers in Ireland. So first of all, it's the Pay Transparency Directive, and pay is defined very expansively in the directive to include basic salary and all complementary or variable components, whether in cash or in kind, and that includes bonus, overtime, compensation, allowances, statutory payments, and contributions to occupational pension schemes. So very, very expansive definition of pay, and we'll see in a moment why that becomes relevant. So the first key obligation that employers in Ireland need to be aware of, and which will flow from this directive, relates to recruitment. So employers will be required to disclose the initial salary or salary range for a role, either in a job advertisement or at some point to candidates before the interview. It may not be necessary to publish the salary range in the advertisement itself, but that information must be provided to candidates. In addition to that, as mentioned already, the obligation relates to pay ranges. So in addition to publishing salary, it will also be necessary to give an indication of the variable compensation and benefits that will be available. Employers will no longer be permitted to ask candidates about their current pay or their pay history. Having said that, the directive it goes without saying, will not prevent an employer and a candidate from negotiating a fixed or variable pay, which is outside the stated pay range. Okay, so one to watch. Let's see what the draft legislation says about this in terms of understanding exactly what has to be done. The second interesting development relates to new employee information rights. And those information rights relate to pay setting information, pay progression information, and average pay levels broken down by gender in relation to the category of workers in which the employee works. So let's break that down a little bit. First of all, employees from June 2026 will have a right to receive information on their individual pay level. And that means employees are entitled to understand why their individual pay is set and structured as it is. And clearly the employer will have to be able to explain that by reference to gender neutral criteria. So that's the first obligation under this new suite of information rights. The second obligation has a little bit more complexity to it. Employees will also have the right to receive information regarding the average pay levels for categories of workers performing the same work or work of equal value broken down by gender. Okay, so what that means is employers will need to be able to identify the correct category of worker in which that employee works. So it means those who are performing the same work or work of equal value as that employee. It's probably worth looking at the definition from the directive as to what category of worker means. The directive tells us that it is workers who are performing the same work or work of equal value grouped in a non-arbitrary manner based on the non-discriminatory and objective gender-neutral criteria referred to in the directive. Okay, so when you look at what gender-neutral criteria is, that means criteria such as skills, effort, responsibility, working conditions, and if appropriate, any other factors relevant to the specific job or position. What is very obvious about all of these criteria is that they are gender neutral. What is also obvious is that it is not open to employers to construct arbitrary categories of employees. So the fact that an employer might put a label on a category and say this is a category of workers in respect of which we will give you that pay transparency information, it is open to the employee to challenge that. So it needs to be a non-arbitrary category of workers. So interestingly, employees have the right to receive this information through employee representatives or through an equality body. That's an interesting development from an Irish employment law perspective because the role of employee representatives is relatively limited under Irish employment law, pretty much confined to collective redundancy situations or where there is a transfer of undertakings. We expect guidance and draft legislation should clarify the scope of these obligations in due course and what this means in practice. So probably worth pausing for a moment just to think about what you can be doing now as an employer in Ireland to prepare for this. I think probably three pieces. The first is evaluating and monitoring current pay structures. Just bear in mind that compensation decisions that businesses are making now and in the coming months in respect of 2026 will form the basis of responses to the first information requests, which will at the earliest come on stream in June of 2026. It is probably a good idea to start trying to identify categories of workers at this point and paying particular attention to where you have a lot of individual contributor roles. So asking questions such as what category do they belong to? Are we able to explain any pay differentials with others in that category? And what is that explanation? And hopefully that explanation is very clearly going to be related to factors other than gender. So a little bit of work to do in relation to that. Probably a third piece to start thinking about is ensuring that employers have a coherent performance management structure which is consistently applied. And that will ensure that progression and reward and compensation is based on merit and achievement, and it is based on evidence-based factors which are entirely unrelated to gender. Okay, so just to recap, we've talked a little bit about the obligations in relation to how recruitment will be handled, flowing from the Pay Transparency Directive. We've talked a little bit about the requests for information, so pay setting information in relation to the individual, average pay levels broken down by gender in relation to categories of workers. There's a third limb, which is employees now have the right to information on what's called pay progression. And what that means is information on the criteria used by employers for pay progression. In essence, this will help employees to progress to higher pay levels because they will have a better understanding of what the demands of those various rungs on the pay scale are. Again, pay progression information needs to be compiled by reference to objective and gender neutral factors. Okay, so recruitment, employee pay transparency information, and the third limb is a prohibition for employers in Ireland on pay secrecy, which will take effect from June 2026. So what this means is employers will not be able to contractually prevent employees from discussing or disclosing their pay where that is done for the purposes of enforcing equal pay rights. Employers can still restrict the unlawful use or disclosure of commercially sensitive information and confidential information, but it remains to be seen how these competing rights, so the rights under the Pay Transparency Directive of employees to freely speak about their pay versus the right of an employer to protect their commercially sensitive information. So again, look, the draft legislation may cast some light on this, and we will prepare an update on that when that happens. Just one other point around these information requests. A response will have to be provided to these requests within a reasonable period and in any event within 2 months of the request. Okay, just a couple of other brief points on pay transparency. Under the directive, the Pay Transparency Directive, there will be enhanced gender pay gap reporting obligations. So gender pay gap reporting obligations apply to employers in Ireland from this year, actually, with a headcount of more than 50. Okay, so what the directive now provides for is enhanced gender pay gap reporting, drilling down to categories of workers. So we talked about those a moment ago, and what this means is that employers are going to have to report on the gender pay gap at a deeper level, drilling into those categories of workers that we talked about. And these reporting obligations are expected to come on stream on a staggered basis from 2027 to 2031. We cannot rule out that the draft legislation here will actually bring those enhanced gender pay gap reporting obligations into force sooner. But for the moment, it looks like that will be introduced on a staggered basis by reference to headcount from 2027 to 2031. Okay, there's also provision for joint pay assessments in the directive. Again, we await the draft legislation to understand what that is going to look like in practice, but just very briefly, a joint pay assessment can be triggered by employee representatives where their employer reports a gender pay gap of 5% or more in any category of workers where that gender pay gap cannot be justified by objective gender neutral factors. Okay, and it is not remedied within that 6-month period. This is an interesting development because, as we've already noted, there are relatively limited circumstances where employee representatives have this type of power to interrogate and direct and inquire and partner with the employer effectively to try to address pay inequity. So that's a new right, and it remains to be seen how that will actually work in practice. Okay, there's one final piece that we want to talk about before we close our wrap up of the year, and we wanted to touch on redundancy. Certainly our experience in the market at the moment is we're seeing quite a lot of restructuring by employers in Ireland. A lot of employers are scrutinising the way they do their work, where they do their work, how many employees they use to do their work. And I think it's a common theme that many employers are implementing different and more agile ways of working. So naturally, all of that can have an impact on headcount. So we thought it might be helpful to wrap up the podcast this year by looking at a really important decision of the Irish High Court, which was delivered in March of this year. And this is the Debenhams case. So just by way of brief background on this, regular listeners to the podcast may remember we touched on this before, that Debenhams, a well-established, long-established retailer actually both in the UK and in Ireland, closed its doors during the pandemic back in 2020, and more than 1,000 jobs were lost. 800 employees in Ireland filed claims alleging breaches of their rights under Irish legislation governing collective redundancies, specifically as it related to the employer's obligation to provide information to them about the proposed redundancies and to meaningfully consult with them at the earliest opportunity and at least 30 days before the first notice of dismissal issues. So this was a long-running piece of litigation. We don't plan to go into the WRC case and the Labour Court case. We just really wanted to highlight for employers in Ireland some of the key takeaways from that High Court decision. So in terms of the factual background, because it's relevant to the key takeaways that we're going to summarise for you in a moment, on the 8th of April 2020, the UK parent company of Debenhams Retail Ireland, which we refer to as Debenhams in this, basically advised its Irish subsidiary that it could no longer provide funding to them. So the board of directors of Debenhams, the Irish subsidiary, held an emergency board meeting on the 9th of April 2020, so the next day, and it decided to cease trading. It also recommended to their shareholder that it would take immediate steps to petition the Irish High Court to wind up Debenhams and appoint a liquidator. So interestingly, employees were notified of this development on that date, on the 9th of April. The way Easter fell that particular year, there was an intervening sort of 4 or 5 days, the Easter bank holiday weekend, after which on the 14th of April, a provisional liquidator was actually appointed. A letter was sent to the employees in Ireland by Debenhams, giving them the information that was required under the Irish legislation, but consultation didn't formally start until the 17th of April, so 3 days later. So against all of that backdrop, what happened and what are the key takeaway points for employers in Ireland? Well, I think the key takeaways are probably the following 3 points. First of all, the High Court decided that the employer's obligation to start collective consultation arose on the 9th of April 2020. So that was the date when the Irish board decided that it had to cease trading. So the employer was late in commencing that collective consultation. So that's the first piece. The second piece is the High Court decided that a collective consultation process can actually commence before the holding of the first consultation meeting. And in this case, the High Court decided that it actually started, so the collective consultation actually started on the 14th of April and not the 17th of April. So the 14th of April was when the letter issued to the employees, giving them the information required under the Act. And the 17th of April was actually the date of the first consultation meeting. But in deciding this, the High Court noted that the consultation process is, and I've just lifted a quote from the judgment, a process that can start in advance of the first consultation meeting by the provision of the information on the proposed collective redundancies. So that is what happened in the facts of this case. And the High Court noted that the obligation to start consultation at the earliest opportunity which is the wording in the Irish legislation, must be interpreted by reference to the factual considerations at the time. So a peculiarity, if you like, of this case was that the country was in the midst of a rather extraordinary situation in April 2020 in the pandemic. There were a couple of public holidays in there at the time as well. I'm not sure that would be terribly persuasive, but in any event, the fact of the pandemic was not lost on the court. The third point then was that the High Court decided that there was no basis in law for awarding compensation to the employees for a breach of their rights under the Irish collective redundancies legislation because there was no evidence that the employees had suffered additional distress due to any delay on the part of Debenhams between the 9th of April, when they should have started consultation, and the 14th of April, when consultation actually started. So one other piece for listeners to note is that while it remains clear that the obligation to consult with employees is triggered early, it is definitely interesting that the High Court decided that this can commence at an earlier stage than the first consultation meeting. That, of course, is extremely important in collective redundancy situations because of the fines and penalties which can flow from not complying with the very strict deadlines. Okay. So that concludes our wrap up for 2025 and our brief look forward to 2026. We will be back in the new year with a continued series of the Maples Irish Employment Law podcast. I want to say a huge thank you to Ciara and Christina for putting together all of this material. Some really crucial updates, some very clear guidance that you have prepared. So thank you very much for that. There's a lot to consider. So we will have one more podcast that we're going to drop before the end of year. We're going to talk all about leave, and in particular leave over the holiday and Christmas period, as well as some top tips for employers as we approach the holiday season. For now, thank you for listening to the Maples Group Irish Employment Law podcast. If you have any questions or queries on any of the points covered today or on any employment legal issues in general in Ireland, please do get in touch with us. Thanks for listening and subscribing.